Assalamu alaikum wa rahmatullah. Welcome to everyone to the fourth, a series of five webinars on living with purpose, looking at the some of the Islamic maxims. Once again, we're privileged to have our brother Muhammad Nuruddin Limo with us. And for those of you who may have missed some of the previous webinars, I have been sharing the link to the previous webinars. So I'll share those YouTube links for you, inshallah, as well as the reading material which goes along with it. But for now, I'll hand over now to our brother Nurdin, inshallah, for the fourth in our series, inshallah. Assalamu alaikum wa rahmatullah. Brother Nurdin.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وأصحابه أجمعين. Assalamu alaikum wa rahmatullahi wa barakatuhu. Firstly, thank you for this opportunity, and may Allah bless and continue to guide us all. We have been discussing over the last couple of episodes the subject of the Islamic legal maxims, and that's how they're usually classified. But of course, as we've said again and again, if you look at these maxims more carefully, we find these are like the proverbs and the sayings, the aphorisms, condensed wisdom, the shorthand abstractions of the Quran and the Sunnah, that guide decision-making. As a subject, the Maqasid of Sharia, the Qawaid al-Fiqh, is an early articulation of the spirit of Sharia. And the major maxims, the five we are looking at, would be the spirit of Sharia in 5 sentences. Like traffic rules, knowing Islamic legal theory, usulul fiqh alone, without the knowledge of qawaid, is similar to somebody knowing how to drive a car, but not knowing the traffic rules. You may know how to start the engine and move forward and backwards, but you're going to start hitting others very soon. And so to complement the subject of usulul fiqh, Islamic legal theory, or the principles of Islamic jurisprudence, in the tools of ijtihad, qawaid al-fiqhiyya, these Islamic legal maxims have played a very important role in triangulation, in helping see and identify mistakes in ijtihad. Another subject that the qawaid try to encapsulate in a very summarized way are the objectives, the higher intents, or the maqasid of Sharia. And so, as we saw in the first of the maxims, al-umur bi maqasidiha, which simply is matters are judged and assessed based on their purposes, whether it is the intended purpose or the realized purpose. In other words, the sincerity, what was going on in the heart, the intention, but also the ends, the consequences. The second maxim that we discussed, al-yaqeen la yazulu bi-shak, that certainty is not overruled by doubt. And so while the first maxim is concerned with purposefulness, the second maxim is concerned with maximizing certainty, searching for truth, being more evidence-based in decision-making, being more rigorous in our assessment of knowledge, and determining what are we more certain about, what are we less certain about, and always being biased in favor of the evidence and going where the evidence leads us to, avoiding guesswork and just pure speculation, avoiding superstition and anecdotal evidence for evidence that could stand as strong or stronger or proof. So there's this concern that when we come to make judgments in the first maxim, al-umur bimaqasidiha, matters are judged by their purposes, by their intent. There's a concern for the truth, the level of certainty we have in judgment and decision making. The third maxim, which we discussed, ad-darar yuzal, that harm must be eliminated. In the explanation, we found this concern in Sharia about prohibiting what is wrong, removing suffering and what causes harm, and all sorts of virtues, including compassion, justice, that deal with prevention, cure, and building resilience or immunity from the effect of harm. That maxim is very concerned with the problem and how to remove the problem. The maxim we will be looking at today, which I will come back to, is al-mashakka tajlibu taysir, that harm or suffering calls for ease, calls for facilitation. Next time, inshallah, the last maxim we will be looking at, al-ada muhakkama, that custom has the weight of law, is a basis of judgment, that when it comes to people's customary practices, the default position of Sharia is that it should be respected above any other custom or tradition. And this is an important maxim in Usulul Fiqh, in the principles of Islamic jurisprudence. It features in some detail under the consideration of urf wal ada, people's customs and norms. So today we will, inshallah, focus on this fourth maxim. It's a maxim that focuses primarily on the victim of the problem as opposed to the problem itself. So while the maxim we discussed last time, ad-darar yuzal, focuses on the problem, the hardship, the harm that needs to be eliminated, like poverty, or anything that is harmful, like prohibiting intoxicants. Here, the maxim al-mashakka tajlibu taysir is focusing on the hardship that the victim is going through. And what this maxim is saying is that al-mashakka, which is worthless suffering, it's not just difficulty, like the difficulty of fasting, or the difficulty of exercise, or the difficulty of going for work. Those are things whose benefits are greater than their harm. It is where the harm is greater than the benefit, or it's just worthless harm. Suffering may be another word, that the victim needs certain types of concessions. And so it is basically taking it that when we talk about a person who is in a state of mashakka, who is in a state of constraint, this constraint may be because there's freedom for others to hurt them or circumstances to hurt them. It may be because laws constrain the person from the freedom to act and protect themselves. And so what this maxim is focusing on is there should always be compassion to victims of worthless suffering. These may be victims that are just the side effects of somebody's good idea. And so instead of only focusing on removing problems like poverty, while we're in that effort to remove poverty, certain problems are what some describe as infinite games. It never ends. We never end diseases. We never end all forms of poverty. We never end oppression. We never end injustice. So long as humans have the choice between right and wrong, some will choose wrong. And they will be victims. And so instead of just focusing on solving problems, let's look at certain palliative care, certain first aid, certain things we can do that focus on reducing the impact of the problem on the victim. For this purpose, scholars classify harm into two major categories. So there's the kind that is not recognized as a harm. That would be a person who is still in a state of comfort. It may be inconvenient, but it definitely is the norm for many people. So that person is in a state of tahsini, so that's not considered hardship. Hardship is a deeper level where you are no more comfortable. You're in a state of haja or darura. Haja is a difficulty that can be tolerated. It's not desirable. It's not useful. The harm is greater than the benefit. Whereas darura is a much more greater context of difficulty. It is the most severe form of hardship and suffering that creates fear, that is debilitating, that creates serious anxiety, that can be life-threatening, but doesn't have to be life-threatening. So a person whose clothes have been stolen can survive. His life is not threatened, at least not in the short term, but his dignity is threatened, and he cannot perform. She cannot perform. They can't just, manage life and just go ahead. Darura is the state of severe hardship that a person faces when the essentials of life, what are called the daruriyat, in the language of Maqasid, the 5 or 6 essentials of deen, of life, of mind or intellect, honor or family, wealth and property. When these are threatened, a person is said to be in darura. When they are comfortable, they are said to be in a state of tahsini. When it's in between the two extremes, such a person is described as being in a state of haja. Now, both darura and haja, a situation of darura, dire necessity, and a situation of need, haja, that is not dire, but it's definitely not a state of comfort and luxury. These both call for concessions in laws. Depending on the degree of the need or necessity, depending on the situation faced by an individual or community, there are various legal maxims related to this one that states al-mashaqqa tajlibu at-taysir, that hardship begets facility or calls for ease. There are various other legal maxims and secondary sources of Islamic law that come to operate in relieving victims and ensuring that legal instruments continue to serve the role of compassion, that the law is never an instrument of tolerating oppression, let alone making things worse. So these help in preserving the intent and objectives, the maqasid of Sharia, until situations get back to normal. So we find, for example, in Usulul Fiqh, in Islamic legal theory and the principles of Islamic jurisprudence, what is called istihsan, or juristic preference or juristic discretion, is a tool used to facilitate ease, ensure fairness, where the normative or standard law might cause harm. Another tool, saddu dhariya, blocking the means, preclusion, in other words, prohibiting what is permissible, because if you don't prohibit it, it would cause harm. So and we discussed some of these last time. So the speed at which you drive or ride a motorbike is not restricted by the Quran or the Sunnah, just as the age at which you hold a weapon, or the age at which you get married, or there's just so many things that are left open to common sense and culture and family to regulate. But where it's clear, this lack of regulation, maybe it's laws that have not been codified, and that lack of codification is creating a problem, then what was earlier permissible would be restricted or prohibited using this tool called Saddu Zaria to avert harm. The unstated goods, what's described as Masali al-Mursala in Usul al-Fiqh, is another one that scholars use in Usul to ensure benefit to the community. So what we find is this maxim is related to the Usul of Fiqh, the principles of Islamic jurisprudence, the methodology of ijtihad, in, as we said, triangulating and supporting the principles of Sharia to ensure that harm is not caused. The moment text gives a ruling like alcohol is prohibited, that ruling is under the assumption that the person is not in a state of mashakka, not in a state of dire necessity. When we say pork is prohibited, it's assumed that the person is not starving. And so when we say alcohol is haram to consume, that's the hukum, that's the default ruling of Sharia based on clear text and evidence. When, however, the condition of the person changes from a state of tahsini, of comfort and luxury, to one of haja, difficulty, or even severe hardship, a situation of darura, then the ruling changes, and that new ruling is usually called a fatwa. So a hukum would be the ruling irrespective of the context, so that's the default position. But once there's a clear change in that context and a person is now in a state of difficulty, then the ruling changes and the temporary ruling becomes a fatwa until things go back to normal, if they do, and depending on how long the duration of the challenge or the difficulty is. So every time we say pork is haram, it is important to remember that pork is haram according to the Quran and Sunnah, but according to the Quran and Sunnah, whoever is driven by necessity to eat pork, and that's the context of the verse, and it appears twice in the Quran. So it's the same Quran that says if you're driven by necessity and you do one of these things or some of these things that are normally haram, there is no sin on you. It's important to recognize that the same source of the hukum that says pork is haram is the same source of the change in the ruling. You could say the hukum that for a person who is starving, for a person who is in darura, the haram becomes halal. The reason why it's important to recognize this, and in the jargon they would say the ahkam al-taklifiyah, the classifications of things for adults into fard and wajib, what is compulsory and what is mustahab, encouraged, what is mubah and permissible, neither encouraged nor discouraged, and what is makruh, discouraged but tolerated, and what is haram, prohibited, that those rules come from clear evidence. It's usually from the Quran and Sunnah. Of course, rulings could be made haram based on qiyas, reasoning by analogy. It could be haram based on ijma. It's not all rulings that that Islamic jurisprudence bases directly on the Quran and Sunnah. Sometimes because of silence or ambiguity, the secondary sources, as they are often called, are sources of ijtihad. And these could be ijma and qiyas and amal ahl al-Madina, maslaha, saddu zariya. So a lot of these, and we've discussed some of these in earlier sessions. The reason why it's important to remember that both come from the Quran and Sunnah is because some people are so tied to the rulings when people are in a state of comfort that they do not extend the compassion of Sharia to a situation where standard temperature and pressure has changed, where new situations, new contexts are being faced, and somebody actually should, from the Quran and Sunnah, be allowed to eat pork. Somebody should be recommended to make a blasphemous statement based on the Quran and Sunnah because it's his situation and it'll save his life. So we find Ammar bin Yasir, a respected companion of the Prophet, who was forced to make blasphemous statements about denying Allah and the Prophet. He felt very guilty for what had happened under duress. He was forced to, he was threatened. And when he came to the Prophet and said, this is what I did, and the Prophet asked, did it come from your heart? And he says, no, it didn't. His heart was stable with Iman, with faith. It didn't in any way come from his heart. The Prophet ﷺ not just told him, there's no sin on you, but also said, next time they torture you and tell you to deny me and deny Allah, go ahead and do so. That's the Sunnah. That's what the Prophet is recommending for the person in duress. Why? Because it's not coming from the heart, and matters are judged based on their purposes. This is not a statement that's coming out of sincerity. So in other words, this is not blasphemous, it's not kufr, it's not shirk, it's not haram in that context, even though in another context, it would be described as haram or statement of shirk, and depending on the evidence, even an act of kufr or something that could excommunicate a person from Islam. So it's important not to prohibit what Allah has permitted when a person in a situation where Allah permits the prohibited to become permissible. Allah permits concessions out of his rahmah, out of his mercy, and it is prohibited. It is haram for a Muslim to deny a victim of a circumstance the compassion of Sharia in the name of no, we have to be strict. Being compassionate is compliance with the strictness of Sharia. To prohibit what Allah has allowed to a victim is itself an act of shirk. It's called istihram. It is making haram what Allah has made halal, just as istihlal, making halal what Allah has made haram, is also prohibited. To understand this maxim, I will cite a couple of other related maxims, and then we'll go into how it is applied, so that it's not just somebody is in difficulty, therefore they get all the concessions and everything is fair game. So one maxim that's always important to remember, it starts in a very unique wording on the side of the scholars. They say, La yunkar tagayyur al-ahkam bi tagayyur al-ahwal. In some wordings, they will say, La yunkar, there's no denying tagayyur al-ahkam or tagayyur al-fatawa. There's no denying that fatwas and rulings change bi tagayyur al-ahwal, with the change of circumstances, or tagayyur al-azman, with the change in times. So once a situation, a culture, a people, priorities, context change, the rulings change to ensure that Sharia realizes its maqasid. So once there's a roadblock to the hospital or to the airport and you're going to miss a flight, Sharia would permit alternative legitimate routes, alternative means of transport. If a bus can't take you, then take a train. If that can't take you, go by a motorcycle or a rickshaw, or There will always be alternatives to ensure that the maqasid of Sharia, the objectives of Sharia, are protected. So this maxim is related to one of the earlier maxims we discussed, at least two of them, al-umur bi-maqasidiha, that matters are judged by their purposes. It's related to the maxim of ad-darar yuzal, removing harm. Here it's removing harm from the individual, from the victim. In other words, take the victim out of his situation or her situation by making things easy. Another maxim related to this is ad-darurat tubihul mahzurat, that necessity makes lawful what is unlawful. In other words, a situation of necessity, and these are all maxims coming directly from the Quran and Sunnah, so just paraphrasing of some of what we've already mentioned. Necessity makes unlawful to be the unlawful to become lawful for the duration of that necessity. A specific harm may be tolerated in order to prevent a more general harm. And so a harm to an individual may be permitted if it will prevent greater harm, or what you'd call what's in the greater interest of the common good or public good. So a private harm would be tolerated in the interest of the general public. So you would find, say, quarantine of an individual or one person or a few people would be permitted if it's going to prevent a disease or an epidemic or a plague affecting greater people. They would also say a greater harm may be eliminated by a means of a lesser harm. And so a harm that is lesser may be used to prevent a greater harm. So surgery is harm, but it's lesser harm compared to the greater harm of a cancer. So that's in the medical sense, but you could have it in many other senses. So we would look at where riba is a harm, but if it'll prevent death, it'll prevent a bigger problem for a community or an individual, it would be permissible. When forced to choose between two evil alternatives, the lesser evil is to be sought. So this is more a summary of some of what's been said, where in weighing options, it is permissible to choose a lesser evil. If one has to make permissible what is prohibited, then choose the lesser prohibition. Also, there's a maxim concerned with consequences, which states that whatever leads to or is a prerequisite for something that is harmful is regarded itself, as it's regarded itself as a harm. But why this is also important is because whatever is a prerequisite for a person suffering more is itself required as something that needs to be eliminated. So not just harm must be eliminated, the sources of harm should be eliminated because they are judged in the same way as the harm itself. But if a person is in difficulty, whatever is a prerequisite for getting them out of that difficulty is itself an obligation, just as removing the person out of the state of necessity or victimhood is itself an obligation. The maxim, certainty is not overruled by doubt, is concerned with the certainty, and here the measurement of harm, just so that we don't take a little harm as an excuse to open and fling the door open for all prohibitions. And so another maxim that is usually cited here is ad-darura tuqaddaru biqadriha, that necessity is measured in accordance with its due proportion. So it's, there has to be a distinction between a dire necessity and one that is not that threatening. And this requires more knowledge, people who can consult, and probably even people who can measure impact in a particular field. So there are different types of suffering, as we've touched, and in determining what to permit, the degree of hardship has to be measured. The greater the necessity and hardship, the more the concessions and the relief. In other words, the more sick you are becoming, the more ill you are becoming, the more the concessions that Sharia would make for your situation. So if you just have a little headache, Sharia will still give compassion. Sharia will still allow you to break your fast. It'll still allow you a couple of things. And the more your situation gets worse, the more things that would normally be prohibited would become permissible. Another maxim related to this states that a need, so something that is a haja, is treated like a necessity when it becomes widespread and general. And so something that's tolerable for an individual may not be tolerable when it starts becoming a society-wide concern. So, and I think in every field we would have, if one person has cholera, no big deal. It's a big deal to the individual. It may, debilitate the individual, but once it becomes widespread, everybody goes on alert. In other words, the more widespread a problem is, the more serious it is. And so even when something is not too serious for an individual, like a flu, for example, a flu to the individual may not be a big problem, but the moment a whole working environment, a whole office, a whole department starts to have a flu, the flu is treated like a darura. In other words, the severity, the importance it's given in Sharia goes up. A need, haja, can be categorized as a necessity, whether it's general or specific. And as we will see, a haja, which is not as dire as a necessity, so say, for example, a woman concerned about having breast cancer, or somebody who feels, I think I'm getting malaria, I am not yet with malaria, or this person is not yet with cancer, but it's taken seriously, even though it's still what you would call a haja. So a haja is treated like a necessity when it becomes general and widespread. A haja, when it is debated by scholars, we find concessions being given for haja, and it's treated as if it was a darura. So inshallah, we will look at a few more examples there shortly. Sharia generally would facilitate ease as soon as constraint is recognized, and the sensitivity to harm, hardship, suffering, this sensitivity and the showing of rahmah, showing of concession to victims of situation is itself a measure of ihsan, of the goodness, of the perfection of a Muslim's character. That when you see something wrong, it may be a suffering individual, you should change it. You should change that situation. You should help as best as you can to remove the suffering. And preventing harm is so important that scholars would say it takes precedence. It's take precedence over accruing benefits. So when the two are equal, Sharia would rather be risk averse and prevent harm than try to accrue an equal benefit. When somebody is in darura, as we've said earlier on, darura is the most severe form of difficulty. Whether it affects a community, whether it affects an individual, Sharia starts to relax laws. And the general rule that applies to this whole subject is nearly all forms of haram are permitted when a person is in a state of darura, when a person is in a state of dire necessity. Minor harams become permissible, major harams become permissible, like the case of shirk, which is one of the greatest sins against Allah. It's difficult to think of something that is greater than, a situation worse than darura. And one of the worst situations is the death of a person. In other words, people should not be allowed to die. Imam Malik would say the only thing that is a lesser evil to one person dying is more than one person dying. May Allah protect us from those type of situations. So we've given examples of people committing shirk or apostasy under duress. There's no sin in that. Certain responsibilities in society, being spies, working and giving misinformation, deceiving for the purpose of security reasons, is regarded as permissible. And this is, of course, an area that some people work in for a good amount of their lives. Pandemics, epidemics would require new laws to ensure palliatives and priorities given to victims, to the elderly, to the frontliners. We saw that during COVID, when a woman was raped during the time of Umar bin Khattab, and it was statutory rape. It wasn't like, the classical rape. This was a woman who got pregnant. Her case was brought to Umar, and he asked what had happened. And she said she was in the desert. She needed water. She was lost. And the person said he would only help her if she allowed him to be intimate with her. And that's what happened. And Umar said she has no fault. She has no sin. Eating and drinking what is usually haram. So I think there are a lot of things from the area of darura that most of us, I think, already know that when life is threatened, laws need to be relaxed. What is less common for many people is when people are in a state of haja. People are in a state where things are difficult. They're not yet life-threatening, but yet we find some of these relaxations. We've touched some of this in the past. So during the time of the Prophet ﷺ, Zubair bin Awam was allowed to wear silk, even though silk is usually prohibited for men. When he had a skin illness that normal clothing made worse, so he was allowed to do something that was prohibited, even though his situation was not life-threatening. A companion, As'ad bin Karim, was allowed to wear a gold mold for his nose. His nose was cut off in the pre-Islamic time, and he wore, while he was a non-Muslim, and he wore a silver mold, but then it was reacting with his skin. It was oxidizing, and he asked the Prophet whether he could use a mold made of gold, and the Prophet allowed him, even though usually for men, wearing gold would have been prohibited. The Prophet allowed a person who had not seen the woman there was an arranged marriage, and which was common until modern times. But he had not seen the woman he was going to marry. And the Prophet, who was told about it, the man told the Prophet, and the Prophet asked him, have you seen her? He said, no. The Prophet said, well, go and look at her. Perchance you will be more interested. To go and look at a woman you're not yet married to is haja there. It's need. It's not necessity. It's not life-threatening. But usually to go and look with the hope that you would be more interested in this person would usually be prohibited. And so medical tests for all sorts of uncertain illnesses that would imply exposing the aura and touching parts of the body of a person which normally would be prohibited are permissible, even though the person is not in a state of darura, not in a state of dire necessity. And there are many examples of this. Another case where haja becomes permissible is where there's a debate among scholars regarding something that is prohibited. And so it may be a prohibition in one madhab, but permissible in another madhab. But once there's a need, then the disagreement among scholars is treated as a source of rahmah. It's actually just viewed as diversity, and the sunnah was to pick the easier one, especially when somebody is in a state of difficulty, even though they are not in a state of darura. This is usually the basis for what is called talfiq. Talfiq is the choosing or going with the opinion of another jurist or another school of law. And this is justified, especially when it's clear that the default law would not realize the maqasid or may lead to harm. And so in the Hanafi school, for example, we find a lot of rules that apply to zakat that would accommodate not just the main forms of foodstuff and wealth during the time of the Prophet and his companions, but accommodate other things. Whereas you would find in the Maliki school, even if you are a millionaire from fish farming or poultry farm, there's no zakat on that. There may be zakat on your profit that has stayed around for a year, but no zakat on your profit, even though you're a multi-millionaire. Zakat will be charged on the person selling rice, even though he's not a millionaire, but not on the person selling watermelons or tomatoes, even though he's a multimillionaire, or yam or cassava, even though these are staple foods. So you will find the Hanafi fiqh allowing succor and help for poor who live in places where the staple food would be a root crop, like potatoes in Ireland, or sweet potatoes in another part of the world, or plantain, or yam, etc. The Hanbali school, for example, would give more flexibility and options for a marital contract than most of the other schools would accommodate, which in modern multicultural, multi-madhab contexts is very useful, where sometimes it's the woman that is working and earning, and the man is the one that sensibly should be, either because he's not as qualified or can't help the family. It's not removing the obligations, but it allows them to come up with a marital contract that ensures fairness in the case of divorce. In the Hanbali school, for example, they would accommodate zakatul fitr in the form of cash, which many of the other madhabs would insist it has to be in the form of food, but where the poor in urban areas can't cook raw food, if you give it to them, they would end up probably selling it at a very cheap price. It may be more beneficial to the people in Haja, the poor who are in a situation of need. It may not be as desperate as darura, to give them something from another school of thought. In the case of the topic of blasphemy, for example, most of the schools consider it as a capital punishment, and that they would not accept repentance of somebody who blasphemes against or insults the Prophet ﷺ. Whereas you find within the Shafi school, there is the acceptance of repentance of a blasphemer against the Prophet. So in many places where it's difficult and the government is stuck with what to do, debate, and all sorts of situations, you find the differing opinions within the schools as a way out of darura, or a way out of haja. The issue surrounding abortion of a rape victim. The rape victim may be an unmarried student. It may be somebody who would go through a lot of hardship, not necessarily she would die, she's family is wealthy and all of that, but it would mess up a lot of her life if she was to take the pregnancy. It may be somebody who got pregnant from her boyfriend, and she's going to really suffer as a result of that pregnancy and taking care of the child, especially if she looks at her family, the context, etc. The Hanafi school would discourage but permit such an abortion if it was done before the end of 120 days or a 4-month period. And so in cases where the other madhabs usually would say it's only the life of the victim being threatened, the mother being threatened by the child, that would permit abortion. In the Hanafi school, before 120 days, in the Shafi school, before 60 days, and there's diversity of opinion here, but that diversity is used to give rahmah to victims of rape and ensure that their hardship doesn't get worse, and the differing opinions becoming a basis for rahmah among scholars and for the victim. We find differing opinions regarding giving zakat to non-Muslims. However, you will find scholars saying if a community is in haja, where you find interfaith relations is very important and it's strained, then it would be permissible to give zakat to non-Muslims. Even among the fuqara, the masakin, the mu'allafatu qulubuhum, the fourth category of zakat, mu'allafat qulubuhum, is understood by scholars to accommodate non-Muslims. Some, however, try to interpret it to say, no, that's not viable or it's been abrogated. However, when a community is in need of building relations, then the debate among the scholars is used as a basis for picking the opinion that gets the community out of that haja. And as we've said before, a state of haja, when it affects a community, is treated like a darura. So there's a debate among scholars on whether you can say Merry Christmas or not. And greeting people during their religious festivities and sending them cards and all of that. The scholars would say once a community is in a state of haja, it is treated like a darura, and such things should be actually recommended if it's going to help build relations. So here we find that a community facing haja allows what is usually prohibited to be treated as permissible, or the other way around. But for the community that is a victim, and we see this in many cases during the time of the Prophet ﷺ, during the Treaty of Hudaybiyah, there was civil unrest. There was no peace treaty. There was what you'd call national insecurity. Meccans or any of their allies could attack the Muslims at any time. And so the Prophet conceded, he agreed to the unjust, the prejudiced, the humiliating conditions of the Treaty of Hudaybiyah that the pagans had insisted on. But why did he tolerate it? Because he was in a situation of darura. Even though life was not threatened in a direct sense, the haja of the community was treated as a darura. During the time of the Prophet, and also during the time of Umar, there was the suspension of the fixed, a moratorium on the hudud, those fixed prescribed punishments for theft, not because the individuals concerned were in a state of darura, but the society was getting ready for battle. There was a state of insecurity. There was preparation for battle, or in the case of Umar, it was a case of food shortage and drought, and people could starve. And so that state of difficulty, even though it was not yet what you would call a case of darura, was treated like a darura, because if a community is facing haja, it's on its way to getting into a state of emergency, which would end up opening all the doors of prohibition. So it's better to permit something that is a minor haram in order to avert a major haram, such as conflict or people dying. And so this is the kind of reasoning, and as we see the interaction between these maxims, again, working in the civil service, the Secret Service, spies and misinformation and decoys and camouflage and deception for security reasons to protect a community and to protect the public interest is viewed as justified because it is in the interest of the common good. And if you don't do it, unfortunately, you may be harmed with something greater than the one you're trying to avoid. Sitting at a table where alcohol is served is prohibited, Some scholars look at it as prohibited if it is Muslims who are consuming it, because then you are supporting them. Whereas because it's not prohibited to sit at a table where pork is being consumed by non-Muslims, some scholars therefore say it's not prohibited to sit at a table where alcohol is served by non-Muslims, so long as you don't drink. Now, where there are international treaties, political meetings for economic security by leaders, international aid is being sought, and the leader is representing the greater good of his community, that type of haja of a community is treated like a darura and made permissible. Some would permit the same thing and say, well, it's a minor haram, therefore haja allows minor harams, or it allows haram that lead to the bigger harams, the haram of the means, as some would describe them, or would say, well, since there's a difference of opinion, the easier one for a leader in a state of haja would be the one that facilitates the treaties and international relations. Traditionally, laws in Sharia courts were not codified. However, as judges become more corrupt, poorer quality of rulings due to greater ignorance of the relevant fields, many scholars would recommend that Sharia laws be codified, at least on the lower courts, and let equity be done only by a higher court, where they are more competent in that area. We find the prohibition of shaking hands between men and women, but because a political leader would be in a state of haja, even the scholars who would say it's prohibited would make it permissible. Others would say it would be permissible because if you don't, you would embarrass somebody. So you are in a state of haja, not tahsini, and there is a difference of opinion among scholars on this subject area. So we find that people in haja, there are actually multiple approaches through which Sharia would make things easy, permitting art and photography of the naked human body, or working with cadavers, dead bodies, for the purpose of educating students and preventing more harm to living beings would be permissible in, when people are studying biology or medicine or even robotics and other relevant fields. Even a woman who would be, for those who hold it, that it's prohibited for a woman to be a head of state, and there is a legitimate difference of opinion on this topic. But for those who say it is prohibited, like Sayyid Abu Ala Maududi, he considered it prohibited for a woman to be a leader. However, when Fatima Jinnah, a woman, was running for presidency, Maududi supported her over Ayub Khan, who also wanted to be a president in Pakistan in those days. But because he felt Ayub Khan was going to be more harmful to the community, more harmful to Islam, he was a dictator, a former military person. Maududi preferred, in the interest of the greater good, to go with an opinion he normally would have considered prohibited. So there again, you find the difference of opinion making a haja, difference of opinion being a reason why what would get the community out of its difficulty is made permissible. And we find a lot of other rulings related to riba and all of that. So I'll end really by saying this subject area of concessions is not always in the field of specialization of many scholars of hadith or scholars of fiqh or scholars of tafsir. It's for professional assessment and triangulation. It's for professionals to study the level of certainty, especially of measurable harms, whether quantitatively or qualitatively, because they are the ones who can really study the scope of the harm, the severity of the harm, the current state of the victim, the duration, the reversibility, the consequences, the side effect, the cumulative, the strategic impact of these various forms of harm, and better advise fatwa councils or scholars to ensure that Sharia always achieves the just and good ends, the maqasid, the rahmah lil alameen that the Quran and the Sunnah are meant to facilitate and ensure that people do not make halal what is haram, but in the context of this discussion, that they also do not make haram what Allah has made halal. That when people are in different levels of hardship, they have concessions. Unfortunately, the detailed study, even a superficial study of what we have discussed today, is not in the curriculum of hadith scholars or scholars of ulumul Quran or qira'ah and recitation, etc. And so it is important when Muslims are in a state of haja, whether because they are minority or somebody has come to the hospital, for us to be very careful about just spewing out and just delivering standard fatwas of halal and haram when the same Quran and Sunnah, the same sources of our judgment of halal and haram would actually change the hukum or change the fatwa for the person in this particular context. I hope, inshallah, at the end of this, we have understood better the maxim al-mashaqqa tajlibu at-taysir, that hardship calls for concessions, for relief, for ease and facilitation. Where I have made mistakes, I pray Allah forgives me and to continue to guide all of us aright. Jazakumullahu khairan. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Alaikum assalam wa rahmatullahi wa barakatuh. So now the floor is open for questions. So if anybody wants to ask a question, feel free to unmute and then you can ask the question. Or if it is that you prefer to text or to send, you can use the chat, inshallah. So are there any questions anyone would like to ask? Yeah, Afnan, yeah, go ahead.
Assalamu alaikum, and Dr. Riza. I just wanted to check when we say a hardship, who is it that is determining the level of harm? Is it an ulama? Is it down to an individual? Because, for example, the example you gave of the Sahaba who was made to blaspheme. There's also the case where Bilal radiallahu anhu, who had the rock on his chest, he still said ahad, even though he was being told to accept the polytheists. So I'm curious, is that just on an individual level? And obviously more things are permissible than not permissible in muamalat, and that's why we're more flexible with that, or is there some red lines as well, or is it just up to the person or the ulama?
Thank you very much. Briefly, I think there's a saying even in English that it is the person who wears the shoe that knows where it pinches the most. So it's really who's the best assessor of the harm. So if it is a harm to the individual, as in the case of Ammar bin Yasir, and he chooses to blaspheme or to make a statement of shirk, somebody else feels, no, it's not serious enough for me, so I'll manage. Even if he knows he's ready to die, but it's important to remember that situation of hardship that is life-threatening no more makes it a haram. So there's the kind of harm that is best assessed by the individual victim. So I know best whether I should break my fast or not. I know I know the level of my illness, irrespective of what the doctor says. I will take responsibility for my pain. So there is a degree of knowledge of this subject area that everybody needs to know, because you do find people who are with stomach ulcer and all of that, and they're like, no, I'm going to do it when Allah doesn't need your suffering and has actually given you a rahmah there. There are areas where the doctor would be the one who would prescribe. So for example, a mother who is in early pregnancy may say, I can manage fasting. I don't need to fast. I don't need to break my fast because of my pregnancy. It's early pregnancy, so no problem. However, medical doctors who have studied the impact of fasting on early pregnancy say it does have an undesirable impact on the fetus. And therefore, they are the experts of the area who say you shouldn't fast, even though you kind of say, but I can. Because they are the experts of the harm to the fetus. You may be an expert on harm to yourself in some contexts. Where it is social impact or environmental impact, what would happen if we did not regulate hunting? Wolves are all killed. Who's the best to measure the damage that could be caused? So, for example, ecologists and environmentalists would tell you if you remove the apex predators, as happened in the past when they hunted down all the wolves in the greater Yellowstone Park in America, it led to disaster for the environment, everything. I mean, places started moving towards a desert, which some say actually is what caused the desert in Lebanon, some of these areas when lions and the apex predators all were hunted. So you would get experts who would decide. And so in banking, they usually have a team of experts of Sharia, but also they would consult and have discussions with the business strategists and all of that in order to know what's the impact and whether this is a state of darura or haja. So a lot depends on the kind of harm, who's the victim, and who blows a whistle, like who's to be the referee. So it may be a scholar in some situations. It may be the social worker who says, you know what, I've spoken to the court, enough is enough. This marriage is going to be broken, whether the two of you like it or not, because of the psychological fragility of whoever is the victim. It depends. Long answer, sorry.
Yeah, Brother Hussein.
Assalamu alaikum, everyone. Assalamu alaikum, Dr. Riza. Thanks for the opportunity on the fourth one. I hope to catch the fifth one also. And good presentation. My question is regarding the last part of the presentation where we mentioned about females in power, and not necessarily females dominating with both males and females. It actually lead me to somewhat of issue that females in medical field would have a note to it saying that it's not nice to go and see a male doctor in terms of more detailed medical history. Maybe, for example, a gynecologist or some other field. How would you put that out so that there is a clear understanding within those boundaries?
So firstly, if a woman is in Haja, so she needs an ultrasound to see the condition of the fetus or the baby. She's not in Haja, sorry, she's not in Darura, nothing life-threatening. So it's not as serious as time comes for delivery and she needs a gynecologist to be there or an expert to help, a midwife to help with the delivery, or maybe there's a complication and this person needs to be on site. Because she is in a state of haja, a state of need, not dire necessity, being seen by a man is not prohibited. However, because it's not prohibited, we should recognize it's permissible only because it's a lesser evil. If we could have women who are qualified, then of course it would be better for women. Having said that, under normal circumstances, a woman looking at the private part of another woman is also haram. But it's a lesser haram than a man looking at it, which is a lesser haram than a group of men looking at it. And so the question is, in every situation, what's the lesser harm? What's the lesser quantity of harm? What's the lesser quality of harm that we can, and haram, so we could say harm and haram are nearly synonymous, that we would tolerate in order to prevent a greater harm of a miscarriage, a greater harm of both the mother and the child dying. It is important to know the position of the fetus before delivery, because then you can expect complications and you can be better prepared and you save lives. And so the expert has become critical. Now we know the expert needs to know some of this information ahead of time. So that state of haja would make it permissible for a man, if he is the only person competent, or we don't have enough doctors. Well, we do have some females, but we're not got enough to go around. So it would make it permissible for a male to see her. Having said that, that's only permissible because of the difficulty. Call it darura or haja. As a general rule, and this we discussed last time, there's the earlier maxim we discussed, ad-darar yuzal, harm must be eliminated. It is viewed as a harm, it's viewed as a wrong for a man to see, let alone touch, the aura of a woman. It is permissible because of darura, but that situation of a man seeing it because of darura is undesirable. And so we should look at how to end it. That may require us as a fardu kifaya, as a communal responsibility, to ensure we are able to bring in more female nurses into the profession, encourage more women to study and be doctors, and especially to be gynecologists and obstetricians, and in all fields that would require women. Women have mental illnesses. Women go to prison. Women, break bones. Women need surgery. Women need dentistry. We should try and have a medical system robust enough to avoid choosing lesser evils. Having said that, the moment somebody is going to a hospital, they are usually already outside Tahsini. Nobody goes to the hospital. It's not tourism. It's not just a visit. And so the moment you're actually going to a hospital to see a doctor, you're probably already dealing with a state of haja or darura, and concessions need to start being considered. Which concessions would be determined by the severity of the situation, which may better be known by the doctor, or better, in some contexts, even the victim, who may be more worried about their situation than is justifiable, and actions will be judged by intentions. So the whole situation should try and be prevented by getting more women in that profession, because it's a fardu kifaya. Fardu kifaya means a collective responsibility, and if it is not fulfilled, we will continue to permit the haram because of darura, which is evidence that we have not fulfilled sufficient people to make a fardu kifaya. Once you don't have enough people to fulfill a fardu kifaya, it is treated like a fardu ain. In other words, the entire community is considered responsible for not solving this problem. Everybody should do what they can to make sure they have enough women in the healthcare system. In some countries, whether be due to poor educational system, whether due to brain drain and flight of labor, they don't have enough women, they don't have enough nurses, they don't have enough doctors, period. They don't even have the choice of male and female. So there you'd find more dire situations. In some countries, they've been able to accommodate the sensitivity and have more dignified medical care for women and men. We don't want a man to be diagnosed by women or vice versa, if that will be more embarrassing. It's one of the reasons that certain health conditions persist, those embarrassing health conditions that affect the private part, or hemorrhoids, or anything where somebody's going to expose their private part, especially if it's a man exposing it to a woman because she seems to be the only expert, or a woman exposing her privacy to a man because he seems to be the only option. And so you find delays in these cases going to hospital really just because of embarrassment. It's embarrassing enough for a man to see the private part of another man. You know, it's worse when it comes to exposing it to the opposite gender. So I hope that answers that question. At the end of the day, a person in Darura must have their concessions. Assalamu alaikum.
Salam. Are there any more questions? Yeah. All right, inshallah. So there are no more questions from our audience today. So this brings us to the close of our 4th of 5 sessions. Next weekend, inshallah, same time will be the last of the series. Look forward to seeing everyone, inshallah, at that session. I will send an email to everyone for if it is that you've missed any part of this recording or previous recordings, inshallah, so you can get access to it. And please feel free to invite others to attend as well, inshallah. And again, thank you very much for all attending, and we look forward to seeing everyone next week, inshallah. Assalamu alaikum wa rahmatullah.
Wa alaikum assalam.
Jazakallah khair for the knowledge. Very good. Alhamdulillah.
Hayakallah. Hayakallah. Thank you.
But Afnan is now working with National Zakat Foundation.
Ah, in the UK.
In the UK, yes.
Congratulations.
Jazakallah khair, alhamdulillah. I'm really glad to hear you mention Zakat actually and the Hanafi difference as well. I'm learning this now as myself. It's because the Hanafi view it as ibadat, isn't it? And everyone else views it as mu'amalat. So I think it just changes all the rulings and understandings.
Yeah, that's definitely a major part of it. And the fact that I think Hanafi fiqh developed in a context with a lot of business going on. And Abu Hanifa himself was a businessman. He clothes, what do they call people who sell clothes?